Hi everyone, this is Saunak. I hope all of you are doing well in these trying times, and I really appreciate the effort of Column of Curae in order to have me here for a few sessions based on Moot Court techniques. And so I have proposed that we will divide these sessions for your benefit into three segments, where in the first segment we'll deal with the pre-memorial stage, in the second segment we will deal with the memorial stage, and in the third segment, we'll deal with the post memorial, or rather, if I may just place it as the oral rounds. So we'll focus on the oral rounds in the third segment. So the first segment that we'll be dealing with today is the pre-memorial stage, which I have further divided into three segments. Firstly, the pre-release of moot proposition stage. Secondly, it will be what one should do once the moot proposition is released. So we'll be covering such aspects. And thirdly, we'll focus on how exactly you should start with your research, what all research methodologies should be followed by an individual who is trying to prepare for any moot, and thereafter we'll end the session so that in the very next session we will touch upon how exactly you should go about the next step, that is memorial making. And lastly, we'll conclude with our third segment of session, that is focusing on the oral rounds. So, starting with the very, very important aspects before the propositions are released, number one is to choose a right mood for yourself. You need to be very particular about choosing the correct mood, because it's completely comes down to an individual's choice. Number one. Secondly, you should be completely comfortable in the area of law that the moot court is proposed or is ideally scheduled in those lines. Therefore, if you are really interested in constitutional law, then make sure you go for some moot which deals specifically with constitutional law aspects, instead of going to some moots such as competition law, etc. I'm not saying that you should not go out of your comfort zone, but all I'm saying is to start with, definitely start with your comfort zone and thereafter go beyond your comfort zone, right? Therefore, you may do one or two moots in constitutional law and thereafter move ahead and do some moots in IP, do some moots in competition law, international law, etc. Second thing that you should keep in mind is choosing the right teammates for every mood. It's very important for you to understand that you'll have to have some really good teammates who will keep you morally and both physically sustained throughout the tiring efforts of 1 or 2 months, or maybe 6 7 months of preparation of one single mood. Therefore, all of you need to be very careful about choosing the right members in your team, and it should be an equally balanced team with good speakers, good listeners, and also good researchers. And a combination of all of three will be the best possible team. Therefore, choose professional teammates, have a professional relationship with your team, make sure all of you are having a common goal of winning a moot, and thereafter just choose what team composition will suit based on you as an individual, as well as what members you are taking into a particular team. For any already allotted moods and already situations where colleges prefix the teams, I think it's good to understand each other and go ahead and highlight the what someone can do well versus what are the negatives of an individual. Highlight those kind of things well and go forward, so that you understand where someone can actually research something in, say, within 10 minutes, versus someone else who will be understanding the same thing in another 10 minutes and will be able to speak and convince someone really well, while the first speaker may not do that. So therefore, just understand the negatives and positives of each and every teammate and go forward with the strategy that will be required for you while fixing your positions in team composition, right? uh, Thirdly, I'll focus on the fact as to what exactly you should do once the proposition is released. Now, once the proposition is released for you, you need to keep in mind that you'll have to at least read the proposition minimum 4 or 5 times before concluding or analyzing the basic areas of law that the proposition tries to deal with, the basic issues that you may frame, and various other aspects. Therefore, it's very important for you to make a timeline of events, if it's a criminal law proposition, never accept that the statements mentioned are facts in itself. The relevancy of each and every fact has to be later proven in the court, and therefore you need to take everything seriously. So my advice will be just prepare a column, maybe divide the disputed facts on one side with the undisputed facts on the other side, so that you focus much on your disputed facts while you use your undisputed facts to connect the dots while making arguments, right? The next thing about the facts is it's very important for you to understand and remember the facts para by para, and even sentence by sentence if possible. So it's always good if you can relate while arguing before the judges in the rounds that your lordships, if para 17, sentence number 4 may be referred, this is the very statement that is given. So if this is the kind of argument you can make while your oral rounds, and that kind of a reference of facts will be crucial for you and will give you the edge over the other sides. Therefore, be very sure to try and practice remembering the para numbers if possible, the data, the measures, the any figures mentioned in any proposition is also equally relevant, and therefore never put a blind eye on any such data, figures, etc., which are mentioned in more propositions. I'll give you an example. If for example it's a situation of a murder, and if the accused is actually charged for giving 15 milliliters of epinephrine as a chemical, which is treated as poison to someone, and if, for example, the defense can come up with some scientific evidence that 50 milliliter is not enough to cause death of an individual, then I think that 50 milliliter reference in the proposition will achieve absolute significance for the rounds, and that will turn around the case in favor of the defense. Therefore, never leave aside these kind of references to data, measures, any figure mentioned, etc., etc. They might be relevant, they might not be relevant, but it's depends on facts to facts as to whether you need to analyze the importance of those kind of data and figures. Lastly, as I said, prepare a timeline of events. Make sure you have a list of dates ready. Make sure, even if it's a civil law proposition or international law proposition, list of dates will always be handy, and you can easily refer to a particular date in one single document if you have all list of dates. If any question is being asked, you can easily refer to the particular date and answer the question to the judge with reference to that particular date. So therefore, a lot of these kind of basic strategies may be followed for you to keep a good grasp over your facts while arguing. Having said that, you also need to understand that what are the undisputed facts, and you need not waste your time much on those kind of undisputed facts where neither any issue or argument may be framed. They might be just used to connect the dots. They might be just used to validate certain disputed facts. Therefore, just understand the relevancy of undisputed facts and use them well accordingly. Lastly, today we'll be covering the aspect of research methodologies as to how exactly you should research for any particular moot. So I'm an old school kind of a mooter when I used to moot back then. So I used to follow the old school methodology. I used to start from the commentaries. If it was a constitutional law moot, I used to start with the Constituent Assembly debates to understand the intention behind the Constitution draftsman for having a particular article or a subclause therein. And for any amendments, I also used to read the parliamentary debates behind the enactments and amendments, and therefore it gives you the idea about the intention with which a particular law was drafted. Secondly, I used to read the commentaries with respect to the previous judgments, right since the law was enacted, and as and how exactly the law was interpreted with changing times, with changes in society, legal framework, etc. So it's very important for you to understand whether a judgment is actually overruled by a subsequent judgment, and in that case, you need not will be wrong word. You should not at all focus on those kind of overruled judgments, and you should never cite them when you are trying to go for orals or even in a memorials, right? Next thing you should then focus on and slowly pave your way and level up your research by way of relying on online sources such as Gestor, Hen Online, a lot of Indian sources like SSC Online, Manupatra, and various other things. Please never rely on something like India Kanun, which can easily be edited and which is, not trustworthy by even the judges of the Supreme Court and the High Courts. Therefore, rely on SSC Online, rely on Manupatra, rely on Gestor, Westlaw, Hen Online, and various other these kind of legal sources which are online platforms. I hope your colleges will be giving you the access to these, sites. If you do not have an access to these sites, please rely on the actual judgments as available in the website of the Supreme Court and the High Courts, and do not rely on India Kanun. I repeat that again. Right. After that, a lot of other reports, scientific data, government advisory, the policy documents, law commission reports, etc., may also be really relevant for your research purposes. I'm focusing a bit on national law in this particular national moods. I mean, in this particular session, we may have another session totally on international law moods. So I'll focus on what should be the research methodology in international law moods in those particular sessions. So yes, coming back, I think you should focus a lot on these kind of extra reports, which will add more validity to your arguments and will make you different from the other teams. I'll give you an example how exactly to effectively cite these, although these do not have any binding value. For you, you need to understand that, for example, if you're referring to a Law Commission of India report, what you can do is you can find out a judgment of the Supreme Court, which has referred maybe to the same report or maybe to a previous report which is of the Law Commission itself. And all you can persuade the bench that see the Supreme Court is relying on Law Commission of India reports, and therefore Law Commission of India reports do have some significance and it may be considered, if not binding. It will definitely have some persuasive value, and that is something you may definitely keep in mind while doing some research. My last advice regarding research: if there is some document which requires scientific analysis, please go for it. If, for example, if it's forensic science related proposition, please do some additional research on forensic science also. And say, for example, whether a particular bullet can just do that particular amount of hole in the body of the deceased or not. So there is some scientific analysis required in these kind of cases. Please do those things, and I hope you will all have a great mooting year ahead. I hope the pandemic ceases down soon, and I hope the situation is back to normal soon, so that all of you can go in large numbers and participate in national moot courts and international moot courts. So I hope to see you in different sessions. We'll segment it out. As I said today, I will plan out and even bring out more sessions if possible. I'll definitely come back with additional information as to how exactly you should go ahead with the next steps. That is memorial making, oral rounds, succeeding with your caliber of oral speaking, etc. So I'll be covering a lot of aspects. Stay tuned. Thank you, everyone.